Don't forget to like, subscribe, and share the videos.
This conference will now be recorded.
Hello friends. First of all, let me congratulate you for your attempt in this 2025 prelims civil services exams as well as the forest service exam. So now I am here to discuss the answer key for polity questions, Indian Constitution and polity questions that was asked in paper 2025 prelims paper. There were about 14 questions asked from polity, which means it is an as usual a number. It's not a there is no big change with respect to the number of questions that are asked in the UPSC prelims with respect to Indian polity and constitution. And I have answered the. I've tried to give. I'm giving the key for the polity questions asked in set A. So that is why I'm going from the reverse. In fact, those who have attempted the questions this time with set A paper, you know, the polity questions began only after the 50th number. Only after 50 questions in set A, polity questions were asked. So I've preferred to come from 100 question onwards. So we are marching reverse with respect to the answer keys. Let us discuss the answer. See, for question number 98, consider the following statements about Lokpal. See, this year, it was again a predicted question only because it was an alternative dispute resolution mechanism and accountability mechanism that was very much in use. In fact, even if you go through the economic questions, there were some certain questions related to ED and revenue intelligence and all. These are all institutions of accountability. So this was somewhat in the current affairs area. With respect to this question, the power of the Lokpal applies to public servants in India, but not to the Indian public servants serving outside India. So these type of, see, there are certain general rules which you could have. There have been several people who have been several teachers who have been guiding you through the YouTube before the prelims. They would have told you certain techniques how to eliminate certain statements, whether these statements are right or wrong. How do I understand the correct or incorrect statements? Of which one important thing is that I always say to my students that when the statement is sweeping, if it is a sweeping statement in my opinion is, or what do you mean by sweeping statements, it will be an extreme statement. It will have superlative words like always, only, the most important, the only important, these kind of statements. When a statement contains these kind of words, that statements are sweeping statements. And generally sweeping statements are wrong unless and otherwise it is qualified, or if it is qualified means if it is subject to certain conditions under these circumstances, kind of, then it is a qualified statement. Or if it is a universal truth, or if it is a thought of anybody, any thinker, any scholar, then it can be right. Otherwise, these kind of statements will be wrong. See, look at this first statement. Serving outside India. This is a misleading words. This is yet another technique UPSC does. It misleads the candidates. The power of the Lokpal applies to public servants in India. To this extent, will be all right. But when it comes to this, there is a possibility of getting confused. When a public servant is a public servant, whether he serves inside India, outside India, he serves for India, he serves for the government of India, which means he is a public servant of India. So where he serves is immaterial. So statement 1 is not right. Same way, the chairperson or a member shall not be a member of parliament or member of state legislature. Only the chief justice. Obviously, this is wrong. This cannot be. This is a sweeping statement. Same way, the chairperson or member shall not be a person of less than 45 years of age on date of assuming. So specific, this is also a kind of a sweeping statement. See, sweeping statements need not only have this kind of words, they also will have specificity. Very specific statements. These are also sweeping statements. These will also be wrong. And Lokpal cannot inquire allegations of corruption against sitting Prime Minister. This is absolutely wrong, because one of the important reforms, or one of the very, very important questions which entails with respect to Lokpal is that Lokpal must have the authority to inquire or conduct an inquiry into a complaint of corruption against Prime Minister as well as Chief Minister also. So all the three statements are wrong. See the explanation, you will understand. The Lokpal has jurisdiction to inquire allegations of corruption against anyone who is or has been Prime Minister or a Minister in the Union Government, or a Member of Parliament, as well as officials of Union Government under Group A, B, C, D. Also covered chapter. See, it is covering even the society, trust, and corporation, or any autonomous bodies. Right? Same way, see, the statement is, who can be the chairperson? A person who has been or is a sitting judge, who has been a Chief Justice of India or has been a judge of Supreme Court, and who can be a member. So all these three things are clear. Therefore, the answer for this question is none of the above statement is correct. D. So let us go to the next question. Next question is question number 91 of set A. See here, this question also has humpy number of extreme statements in all states. This is wrong. That is wrong, because in the provisions of Constitution regarding Panchayat Raj, Article 243B clearly says and gives an exemption. Panchayats at the intermediate level may not be constituted in states having a population not exceeding 20 lakhs. So all states is wrong. They do not exist. There is a provision. Remember, don't get confused. This is again a misleading word. The Panchayat at intermediate level does not exist in all states. There is a provision that every state must have a 3-tier Panchayat system. There is a difference. It doesn't exist in all states. Similarly, to be eligible to be a member of Panchayat at the intermediate level, a person should attain. This is again a misleading statement. See, they try to give a sweeping statement with specificity. See, to be a member of Panchayat at intermediate level, a person should attain 30 years. This is a wrong statement. Why? Because for the eligibility to become a member of Panchayat, it is 21 years. All right. The qualification, see, to be precise, the 73rd Constitution Amendment Act does not prescribe any qualification to the member of Panchayat. It only talks about the disqualification. It only talks about the disqualification of members. Right? In the disqualification of members, it says that as long as any person is qualified, or as long as any person is not disqualified to contest in the elections to the legislature of a state, he shall be eligible to be a member of Panchayat as well. And there is a proviso, provided no person shall be declared disqualified to be a member of Panchayat for a simple reason that he has not attained the age of 25. Because when a person wants to contest for a seat in state legislature, he must have attained 25 years. Whereas for Panchayat, they have made it otherwise. Any person who is qualified to be a member of state legislature shall be eligible to be a member of Panchayats, provided such a person shall not be disqualified on the ground that he has not attained the age of 25 if he had already completed 21 years. The Panchayat election, to contest in the Panchayat elections, one has to be a person of 21 years. That is enough. So for intermediate level, you cannot give a statement that is, any specified prescription with respect to age. And third, the Chief Minister of the state constitutes a commission. See, look at this kind of statements. This is a very misleading statement. See, very, very simple. These statements nobody needs to read if you know that there is a state finance commission. The statement is easily you can eliminate. So the answer for this is, which of the statements given above are not correct? All three are not. Be careful. Someone could have missed reading this, not correct. Then it is a problem. That should be a problem with you, right? Be careful. Sometimes we have the habit of not reading the terms like not correct. So be careful. Somebody would have skipped this kind of questions. This is a non-academic mistake, which I had already discussed in the workshops previously, what we have conducted. What kind of mistakes candidates commit? Fine, let's move on to the third question. The 89th question is the third question. Consider the following statements. In India, the state governments have no power for making rules for grant of concessions in respect of extraction of minor minerals, even though such minerals are located in their territories. Statement 2. In India, the central government has the power to notify the minor minerals. So actually speaking, the first statement itself is wrong, because Minerals and Development Act, the Act very clearly, Section 15 of the Act definitely confers the power upon the state government. So therefore, the statement 1 is right, 1 is wrong. So if the statement 1 is incorrect, you need not read the second statement. So answer is B. Then go to the question number 88, which is the fourth question. If any question arises as to whether a member of the House of People has become subject to disqualification in the 10th schedule, President's decision in accordance with the, see here, very specific. They're going specifically with the opinion of the Council of Ministers shall be final. This is wrong, because when it comes to Schedule 10, the power of declaring any person, the power to make decision with respect to disqualification is vested more in the, rather, not more, the power is vested in the Speaker or the chairperson of the House. With respect to House of People, the Speaker. So statement 1 is definitely wrong. There is no mention of the word political party in the Constitution. That is very, very wrong, because Schedule 10 of the Constitution clearly mentions this term. So both the statements are wrong. So therefore, the answer is neither one nor two. D. Right? Then come to the question 87. This is the fifth question. On the dissolution of the House of the People, Speaker shall not vacate his or her office until immediately before the first meeting of the House of the People after dissolution. The statement is right, because Article 79 of the Constitution, see, the Speaker will not vacate the office even if the House of People is dissolved. Why? Because Article 79 of the Constitution says there shall be a parliament which shall comprise of the President and two houses, namely the Council of States and House of People. In order to give this validity, even after the dissolution of the House of People, the Speaker continues as a symbolic representation of the existence of House of People. Yeah, Article 79 there shall be a Parliament of India which shall comprise of the President and two houses. And a Speaker will not vacate. The second half, immediately before the first meeting. This is called as the lame duck session. The lame duck session, pro tem speaker appointment. Once the pro tem speaker appoint pannone, this office of the speaker automatically goes vacant. Any session that happens after any session of the House of the People after the general election is the lame duck session. It is sometimes considered as the last session of the dissolved Lok Sabha or the first session after the general election to Lok Sabha. I'll tell you the previous question. It is last session of the dissolved Lok Sabha. Ena and the speaker our office of formal vacate panna vechittu program speaker kondu varanum. So when the elections are over, we only have the new members elected. The election commission would have certified that these members are elected to the Lok Sabha constituency from so and so constituency. So these members will come to the house, but they are not members. Unless they assume office, they are not members. That is why they are called as lame ducks. And that is why it is regarded as the last session of the dissolved house, because the members of the dissolved house, they all will be invited to that session, And they are also lame ducks because they belong to a former Lok Sabha and they won't transact any business. That's why that session is called as lame duck session. In the lame duck session, a pro tem speaker will be appointed. Once a pro tem speaker appoints, the office of the speaker will be vacant, will fall vacant. Then, so statement 1 is right. According to the provisions of the Constitution of India, a member of the House of People on being elected as speaker shall resign from his political party immediately. This is a kind of a recommendation. This is a wish. After the passage of the 52nd Constitution Amendment Act, that is the 10th schedule, anti-defection law, it has been many a time, this demand has been placed before many committees and this has not been implemented. See, this is a wish or this is only a recommendation because the speaker has to be neutral. To be neutral, he has to resign from his or her political party, and in case he resigns, he will be exempted from being disqualified on the ground of defection. That clause is there in 10th schedule, but this is not a mandatory provision. So the statement 2 is not right. So now answer cannot be 1 and 2 only, answer cannot be D, and answer cannot be B. If you eliminate 2, you get the answer. Anyway, look at the third. Speaker of the House of the People may be removed from his office by a resolution of the House passed by a majority of all the then members. In the book Indian Polity, Indian Constitution, Indian Polity, written by me, published by Pearson, I have discussed this very, very clearly. What is all the then? This is called as the absolute majority or the effective majority. Right? Absolute majority or effective majority. All right. This is called as absolute majority or absolute majority or effective majority. See, I have discussed this in the book in the chapter number 25. What are all the different majorities? Interstate council, zonal council, this seems there is a question regarding zonal council also, interstate councils and zonal councils also. Let me show you what are the alternate dispute resolution mechanisms. And here I have always given you, I have given you the difference between tax and fees. There is another question regarding the, see, this is the majority required in the Indian Parliament. So what is simple majority or extraordinary majority and extraordinary majority? One of the important extraordinary majorities, the removal of the speaker, deputy speaker, Lok Sabha and deputy chairman of Rajya Sabha. See, this is why we call it as, so this is what we mean by all the then members. I hope it's clear to you. You see, let us now go to the question again. So that is why it is called as absolute majority. Now let us go to the question number 6, next point. Regarding pardoning powers. The exercise of this power by the president can be subjected to limited judicial review. This is right because president's power is subject to judicial review. There have been several cases, K.R. Singh case, right, Gaurav Venkat Reddy case, Sri Lankan Rajiv Gandhi killing, assassination case. So it is subjected to, but the president can exercise this power without the advice of central government is wrong, because he has to, first of all, there is no nothing called a central government. He has to exercise the power with the advice of council of ministers. Because the president is exercising this power with the aid and advice of council of ministers only, it is subjected to judicial. So here there can be one another kind of interpretation. It is not limited judicial review, but judicial review is complete. Therefore, neither one nor two could be the answer. Right? Neither one nor two could be the answer. Do not mark this. This could be the answer. When it comes to judicial review, it is full-fledged judicial review. Therefore, answer is neither one nor two. Please don't consider A as your answer. Answer is neither one nor two, because judicial review is judicial review. President, in the KRC case, the court said that president's power of pardoning is exempted from judicial review. But after the Gaurav Venkat Reddy case, it made it very clearly that the power of the president with respect to pardoning is an executive power to be exercised with aid and advice of the council of ministers. Therefore, it is subjected to judicial review. So the statement is neither one nor, the answer is neither one nor. Statement one is wrong. It is not limited judicial review. It is subjected to full-fledged judicial review. Fine. Coming to the next question. With respect to the Indian polity, consider the following statements. The governor of a state is not answerable to any court for the exercise and performance of the powers and duties of his or her office. No criminal proceeding shall be instituted or continued against the governor during his or her term. These two are exemptions to Article 14, given by Article 361. See, in my book, I have given this. Everybody knows this. And members of state legislature shall not be liable to any proceedings in any court with respect to anything said in the House. This is the privileges of the Parliament and state legislature enjoyed by the individual members. So they have a complete freedom of expression within the House, and as part of the proceedings of the House, if they are speaking or making any statements in the House, they are not liable or answerable to any court for that. So all the three statements are right in this question. Under Article 105 and 194. 194 is the privileges of the state legislature. The next question. Consider the following statements under the Constitution of India. List 1, Union List, in the 7th schedule. Sorry, this is a spelling mistake. 7th schedule. Extent of executive powers of the state, conditions of the governor's office. See, basically, for a constitutional amendment with respect to which of the above ratification by the legislature of not less than one half of the states is required. See, basically, why states have to ratify with respect to certain amendment of certain provisions of constitution. Here you have to understand it very clearly and conceptually. This is an arrangement for upholding the federal setup in the constitution. While power to amend the constitution is a power of the parliament and a non-federal feature, the states must have a say with respect to certain amendments to the constitution that may impact the states. This is under the principle of natural justice, as well as to uphold the federal structure of the constitution, which is a basic feature. So any list in 7th schedule, it can be amended only with the ratification of states. Extent of the executive power of the state, yes. But conditions of the office of the governor, that doesn't fall under this purview, right? So if you understand that this arrangement is more for upholding the federal setup, this you will understand. The statement cannot be, this is not anything, this has got nothing to do with the federal arrangement. Right? So answer is 1 and 2 only. The answer is B, Bombay. 1 and 2 only. Sorry, A. 1 and 2 only. I'm sorry, here it is A. 1 and 2 only. Third statement is not correct. Then we'll go to the next question. Question number 9, whereas here it is question number 56. Consider the following statements under the Constitution of India. With reference to the Constitution of India, if an area of a state is declared as scheduled area under 5th schedule, the state government loses its executive power in such areas and local administration will take over totally. See here again, extreme. It's again a sweeping statement. Here also, but Schedule 7, Schedule 5 never says that. Para 2 of Schedule 5 says the executive power of the state in scheduled areas. Subject to the provisions of this schedule, the executive power of a state extends to the scheduled areas therein. There are certain conditions in the schedule which has to be followed and which has to be upheld. While exercising this executive power, the state shall ensure that the conditions of the schedule are upheld, fulfilled. Otherwise, the state definitely has its executive power intact. If the statement 1 is true, statement 2 is wrong. Or if under the statement 1, the state government does not lose its executive power, then see, basically, if you look at this question, these two statements are already mutually exclusive. Either of the one statement can be correct. See here, the state government loses executive power in such areas and local body assumes total administration. If you see this statement is right, the statement cannot be true. Similarly, if you say that union government can take over the total administration, then this statement cannot be true. Under certain circumstances, on the recommendation of, see, this is a misleading specific question which is very sweeping statement. So when the state government has the power, is executive power intact in the scheduled areas, even after the area being declared as scheduled area, as per para 2 of 5th schedule, neither of these statements can be true. Right? Come to the next question. And this is a very factual question. Separation of judiciary from executive, UPSC. Valuing and preserving rich heritage is fundamental duty, and provision of employment in children below 14 years in factories. So all three statements are correct. All three pairs are matched correctly. See here again. This is a sweeping statement. President of India can of his own reserve the bill without being forwarded with it. So second statement cannot be correct. Constitution explicitly mentions that in certain spheres, governor of a state can, yes. Article 163 mentions that. There shall be a council of ministers with chief minister at its head to aid and advise the governor with respect to performing his duties and functions, except by or under this constitution to exercise the powers in his discretion. So statement 1 is only right and second statement is wrong. Coming to the next question, 12th. Yes. See, Arunachal Pradesh has two national parks, namely Namdapha and Mauling National Park. Itanagar is named after the Ita Fort. So the first pair is correctly matched. And pair 2 is incorrectly matched because Nagaland was formed by the State of Nagaland Act 1962, not by Constitutional Amendment. So this is a provision regarding provisions of the State of the Nagaland Act. And pair 3 is right because after the merger of Tripura, it became Part C state, and on the reorganization of states effective November 1956, it became a union territory, that is centrally administered state, and thereafter 1972, it became a full-fledged state. So only two pairs are correctly matched. So here answer option is wrong. Only given answer is only 2. This is the answer. Forget this. This is not the answer. This is the answer. Only 2 pairs are correctly matched. Then, with respect to India, consider the following: Interstate Council, National Security Council, Zonal Council. While Interstate Council, there is a provision in the Constitution under Article 263. National Security Council was constituted after Kargil attack. This is a current affairs question. It was asked probably because of Pakistan-India skirmishes. And Zonal Council is constituted under the Reorganization of States Act. So only 1 is correct, rest 2 are wrong. They are not Neither National Security Council nor Zonal Council are constituted or established by the provisions of the Constitution. Then, with reference to Indian polity, consider the following statements. Ordinance can amend any central act. Yes, it is true, because an ordinance is the power of the president and the governor under 123 and Article 213 respectively. When the president promulgates an ordinance, it has the effect of the law enacted by the parliament. So the ordinance has the capacity to amend any central act. So statement 1 is right. Ordinance can abridge any fundamental right. Wrong. Ordinance cannot abridge any fundamental right. Ordinance cannot violate fundamental rights, because it is a safeguard against, because it's just it goes, the scope of the ordinance making power is limited by the scope of the power of the parliament to enact law. So in all the subjects where parliament has the power to enact laws, the president will have the power to enact, promulgate ordinance. So it can it be given a retrospective effect? Yes, it can be given a retrospective effect, because any civil law under the Constitution of India can be given a retrospective effect as long as ordinance is not relating to any criminal law. It can be given a retrospective effect. So these are the answers for the polity questions asked in 2025. Check it. I've given you the source as well. You can refer it. And in case of any questions or queries you have, you can feel free to call us on this number. Or you can visit our website, ganeshias.com, and based on the website, you can even mail us. And for any update also, you can watch our channel. So thank you very much, and wish you all the best for your mains preparation. We'll be posting more videos with respect to the preparation of mains as well, how to go about preparing for mains. Let's catch up later. Wish you all the best. Thank you.